Good morning. I'm joined again by my good friends Joe Fantini and Andrew Schneider. Joe and Andrew, this is so much fun.
Good to see you, Michael. Good to be here with you and Andrew. Excited to get into a little bit about the talc litigation and how we got where we are and what to expect going forward.
Yeah, man. And so, you do these Mass Tort Monday conversations, and one of the things you were talking about was talcum powder. You were talking about loan pine orders. So, who wants to kick it off? Who wants to talk about talc bankruptcy, talc in general, the settlements? What does it mean, and what does it mean for everybody else?
Yeah, I can touch on it a little bit and kick it over to Andrew, but um, talcum powder is what I call one of these legacy mass torts. So what I mean when I say that is a mass tort that's been going on for more than a decade, and just right off the jump, there's no case that should last that long. I think we can all agree on that. We've seen with this Depo Provera rocket docket really how to manage an MDL and get the cases moved forward. So hopefully we learned some lessons here. But there were issues with this case, and it had a long winding history. But ultimately, we got to the finish line almost, where we had this $5.5 billion settlement that was recently announced. It was supposed to be for all filed cases. And then there was an addition for some unfiled cases, but those additional cases needed to meet specific requirements about the date of diagnosis and then also the date of retention. So we're still kind of going through the process. And one of the main threshold requirements of this settlement, like we see in most other settlements, is this participation threshold that needs to be met. So in this litigation, it's 95%, which is actually a little bit lower than some of the other mass torts we've seen, 98%. But it's come out that this is just really a minimum amount that needs to be paid. There's the option for additional amount to be funded for this settlement, rising from 5.5 to $7 billion. But before we got here, we saw a bankruptcy attempt that ended up not being successful. And had the bankruptcy gone through, it would have been a much different settlement. So I know Andrew was, really on top of the bankruptcy and has some thoughts on whether that would have been good or bad, and really how that would have changed everything. So, Andrew, could you tell us a little bit about that bankruptcy filing?
I love, I'm the odd man out. I think bankruptcy is the most efficient way to handle everything for mass torts like this because it makes everyone equal. Like it resets all of the rights. Everyone becomes an unsecured creditor, and the unsecured creditor committee negotiates very specific things. And it becomes an efficient process where there's a standardized distribution procedure. There are standardized requirements. They basically, the allegations are that there was asbestos in it. The 524G Johns Manville Asbestos Trusts are specifically for asbestos-related injuries. So J&J weirdly followed the playbook when they did their Texas two-step. They did it 3 separate times. They even got it past the voting majority and had a judge turn around and say no because certain votes flipped, and there was a question about why. So now there is the settlement. It's $5.5 billion. We're waiting to see what the grid looks like. It potentially can go up, and I guess everyone's really excited because it only applies to currently filed cases and I guess specific instances of new cases, but it doesn't go for future cases. But if you have a future case 10 years from now, they're going to issue orders at the end of this MDL settlement that make it harder to file them. So, Joe, I mean, it's a lone pine order. It's what the judge is going to do, and it makes it harder for everyone post MDL settlement to do another one of these.
Yeah, and that's true. The Lone Pine order, we see it all the time. And it definitely adds a heightened burden, but I maybe will disagree respectfully with my
Yeah.
good friend Andrew there. As a mass tort attorney, I don't think we always love the bankruptcy play. I think that maybe some of the defendants could look at it and take advantage and improperly utilize it. And what it does is it really takes away the opportunity and the right, of all of these plaintiffs to get in the courtroom and to have their case decided by a jury. So instead of, having that right that's given to everybody, it's taken away. And we've saw, a lot happen in the last couple of years with this Texas two-step, with Monsanto, with J&J. And I think the threshold issue is these companies that they shouldn't qualify under the bankruptcy code, regardless of if they're spinning off these other companies or creating them to hold the assets. And that would probably have a negative impact, I think, overall on mass torts if every case was just resolved via bankruptcy. I think it's a tool that is okay in certain proper instances, but I think it's in play, and what it does is it pays the claimants less because usually, and correct me if I'm wrong, is it has to include these future claims as well. So here, like you mentioned, this settlement. It could go up, but for these future claims, we're going to need to have this Lone Pine order where if there was the bankruptcy went through, there would have been no requirement for that Lone Pine order, which is basically where you have to come forward with certain evidence of usage, exposure in this case, diagnosis, treatment, and then a case specific expert report, which is oftentimes hard to get and very expensive. So if we had the bankruptcy route, it would have gone on maybe 15 years, and these additional future claims 3-5 years from now could have gotten in, where now in this settlement, like you're predicting is going to happen, I'm sure it will, the judge will enter a Lone Pine order. And that's going to pretty much end, these future filings. I'd be surprised if there's, another 2,500 cases filed after this settlement. I think we'd see less than that.
Joe, you mentioned Lone Pine Order, Andrew did as well. Can you explain, just how does that impact, what is a Lone Pine Order, and how does it actually impact a litigation, a mass tort in general, good or bad?
Yeah, so basically the judges have broad discretion to manage their dockets however they want, and they're able, under the rules, to enter any order that they think is appropriate to help manage it. So what we see all of the times is when there's a settlement, the court soon thereafter, sometimes it's immediately when the settlement's announced, or when we meet the participation threshold, they enter this order, which requires the plaintiff to come forward at the time of filing or soon thereafter with certain evidence. And then also this expert case specific causation report under the rules of federal procedure. It could be within 30 to 60 days of filing. So we've seen it most recently in Depo-Provera. The judge just entered a Lone Pine order there. We have one in Paraquat. We've seen it in other hernia mesh settlements like Bard or Atrium. And so basically with that requirement, it makes it very challenging for the plaintiffs and puts this very hard burden on them where they don't get any discovery or any information. They have to produce it right up front, which is totally different than how a case enters. So usually when a Lone Pine order is entered, it's signaling the end of that mass tort, and only the most sophisticated firms, continue to file these cases.
So it's a good thing, right? Or is that I'm reading through here? Is that the idea that the Lone Pine Order?
From my perspective, probably not
Okay.
a great thing, because these people who get hurt and are diagnosed years down the line, they're treated differently than somebody who was diagnosed earlier. So there's a lot less attorneys out there taking the cases. It costs a lot of money to get these expert reports. So the financial burden placed on these plaintiffs right up front is really enormous, and it makes it hard for them to continue with the case. Is it good overall in bringing about the end of the mass tort and the MDL? It does that right away. That's what happens. So the judge wants the mass tort and the MDL closed, but from the plaintiff's perspective, it's this added burden that is definitely significant, and it changes, how people look at cases. What do you think of Lone Pines, Andrew?
I agree with you. They bring about a close, but if you file after that closing date, you are filing from a place of weakness. You don't get to rely on everything up till now. There is no strength in numbers. You get your day in court. You just have one hell of a burden to overcome to get there. And all of a sudden, it isn't just a plaintiff fact sheet. Adding another name, another claimant ID. Here's the basics, short form joinders. They're going to set up the website to do all the claim submission. And all of a sudden, it's no longer Excel spreadsheet uploads for your entire docket. It's you actually have to rep that individual case if you want to get it to trial. And it becomes unbelievably expensive to do. You now have expert costs associated with one, record retention for one, the filing and the drafting for one. There's no more inventory. So now they get their day in court. It's just under a very different set of circumstances. I mean, MDLs at the end, they kick everything back to the courts. If they don't settle, you don't sign off on it. MDLs aren't class cases. Everyone is still their own individual case. They don't have to accept a settlement. They can say no. And if they do, their case is still their case. So that's why they put in those threshold limits, 95%. Do we think they're going to hit it? I think they get close, but do we need to get rid of, are we going to use dropout clauses to make sure we get closer? And what do we do with dual representation issues that we all know are about to happen? Everyone ready to start figuring out how many lawyers the same claimant signed up with?
Yeah. And I think that 95% threshold, it's likely not going to be met. You're right, Andrew. But the defendants, they have the discretion to lower it. So I can't recall a case ever where they announced a settlement. And then because we didn't meet the threshold, they didn't go through with the settlement. There's always the wheeling and dealing behind the scenes, like you're talking about with dual reps, or now there's a deceased plaintiff and the family doesn't want to move forward. Does that still count as a case? Can they dismiss some cases? So I think the settlement's going to go forward, but that's what the issue and kind of the difference was with the bankruptcy, right? Is that bankruptcy threshold didn't get met, right? Ultimately, and that's what pretty much tanked the bankruptcy. I think if they had gotten the number and gotten some more support, I know there was I guess disagreement maybe with attorneys and J&J on who was in, who was out. But here, since it's outside of the bankruptcy court and it's kind of J&J's settlement, I think they'll be a little bit more lenient, and they want the settlement to go through. And I think ultimately it does.
I agree. It's going to hold. They brought in, you don't have to like him personally, but he gets it done. Chris Seeger, 2 for 2, wrapping up 10 years of litigation in 6 months or less. I mean, I have to ask the question, does that mean that the executive committee took 10 years too long, or is he that much more efficient than everyone else? And the uncomfortable question that the lawyers have to ask, how do they handle that common benefit fee award? He was in for this much time, but there was a result. What do you do for the firms that spent 10 years litigating this and didn't get it to a close and had all of their experts getting 86 right before Bellwether's? The experts were the issue. They had an issue with general causation, right? Right before the end. And it looked like the plaintiff's experts were going to get last minute DQ'd. And they brought in Chris. He got another one done. He got Roundup done right before Durnell. I mean, at this point, let him get in, let him get it resolved. It's not good or bad. There was a resolution.
Yeah, and I think it's good. And I think right now Chris Seeger is the attorney who's known for getting these, complex deals done. I wouldn't be surprised to see his name popping up in other litigations where he might not have the most prominent role throughout, but being brought in. So I'm sure they struck a deal about what percentage he's going to get. It's a little bit different in mass tort settlements than the class action, where we're not looking at the lodestar, which is, the hours billed, which kind of corresponds to how much you should get. We saw a little bit of disagreement amongst some attorneys in the 3M earplug litigation about the award of common benefits, and it went to a special master, but then the attorneys ended up withdrawing some of their submissions. So I think Chris Seeger coming in, everybody was happy to see him there. I think when people, see about these negotiation or settlement teams, when his name's there, I think he's very good at leveraging both sides, because what he did was took advantage of that uncertainty about the Supreme Court decision in Roundup, and then also the uncertainty about the plaintiff experts, when both sides could kind of get a win. And he's great at it. He's probably the best at the plaintiff's bar, probably best in the world right now at doing that. So I think everybody's happy to get this settlement. I think people are happy that it stayed out of the bankruptcy for this specific settlement, and then also for setting a bad precedent, maybe for future claims, and having these, billion-dollar corporations saying they're bankrupt. It would have set a bad precedent. So overall, I think people are happy, but a lot of work, I'm sure, went into getting Chris to that point. And ultimately, the clients are supposed to be seeing some money in the next year and a half or so. So we'll see if that turns out to be true. We know these settlements can drag a little bit, but there's still work to be done. But I think the people I'm speaking with, the clients, the other law firms involved, everybody's happy about this.
It's kind of like when the Yankees were paying a lot of money to Mariano Rivera to come in as the closer. He didn't play a lot of innings, but he was able to win a lot of games and close out games. That's what Chris Seeger's kind of becoming, at least for these two. And maybe in the future, he comes in as the closer. And I think that entitles him to value, right? Like moving the duration and making it a quicker resolution has a tremendous value, right? So you working on a case, I mean, from where I sit, I'm not a lawyer. I didn't do the 10 years, the 12 years of work. So maybe that's out of school for me to say, but someone coming in and saying, hey, I could end this within 6 months, or get us there, get us around to that point. I think that has a tremendous value, and I'm not saying it eclipses the person who worked for 12 years, but I also don't think we over reward people for taking longer. I think there's value towards a shorter duration sometimes. And then you can kind of look and say, hey, this is a situation where this resolved at a higher rate. That's one area, right? This is a resolution that resolved quickly, and that's a secondary value. I think both have a tremendous value. So our Mariano Rivera is now Chris Seeger.
Yeah, and he did it in CPAP, he did it in PPI. So I mean, almost
right.
Every settlement out there in the last couple of years, he's probably involved in half of them. But there's a lot of other really good attorneys. A lot of other work went into it. I think Andrew talks about it a lot. the results at the trials weren't the best maybe for the plaintiffs in this litigation. So I think that's what made this settlement unique. Um, do you want to talk a little bit about that? How that put us a little bit behind the eight ball, Andrew?
Sure. I mean, I was just going to say Chris Seeger is like the definition of the closer at this point, and he's just going to refer back to the common benefit order for Blue Cross Blue Shield, where Quinn's hourly was supposed to be, what did it work out to, $100,000 an hour, because they got a full recovery, 100% recovered of what was lost in it was like the Obamacare litigation. They represented providers, they got 100% recovery. It took less than 6 months. And the court's like, what do we do with this? It's the most efficient outcome ever by any firm, period. They got 100% back, and it took less than half a year of associate hours. Do you penalize them for being that good at what they do? Or do you reward them for not wasting 15,000 hours of billables? I mean, back in the day, I'll take one side note and say people that would do documents for us for like transaction work, we used to have to say to them, don't bill me the hours, don't take 6 months, just charge us what you're supposed to charge us at the end and give me my documents tomorrow. Thank you very much. Like, time and efficiency win. So back to the J&J and Talc and litigation that we've had, J&J settled, what was it, all but one ovarian meso claim from the very beginning. They did not let those go to trial because they didn't have an out. They lost once, and I believe that it got dropped on appeal. It went down. But J&J has won 99% of the trials in talc since the 90s. They lost one major one to Lanier in Missouri. It was 23 out-of-state plaintiffs because Missouri has special jurisdiction. Sue anyone here and bring a friend. Two, if they're small, like Missouri's jurisdiction statute is just everyone can come play. And Seeger got 23 out-of-state plaintiffs, $2+ billion. And then the plaintiffs lost every other trial that mattered. They got any award that was big got killed on appeal. And the vast majority of the cases, J&J got a not liable verdict. And this goes back almost 30 years. The plaintiffs could not clear the hurdle. Seeger deserves all the credit for taking that track record and still getting a multi-billion-dollar settlement that's technically uncapped.
Yeah, and this is definitely one of the biggest settlements, we've seen in recent history. It's bigger than the 3M earplug. If it gets up to 7 billion, it's going to be almost the same as what we saw or going to see here in Roundup that we'll talk about in a coming post. So it's really good. And I think people are happy. But what happened and I think got this litigation a little bit derailed was instead of focusing so much on the clients, we saw a lot of maybe attorneys fighting, maybe some on the plaintiff side amongst ourselves, and then J&J taking it out on some of the law firms. So I think that added some time and duration to this litigation, maybe unnecessarily. And that's why it shows it's so hard to manage these cases where you have conflicting clients, right? And then you have maybe some conflicting law firms with different interests. And that's why it's really important to try to get everybody on the plaintiff side really all working together and working in harmony, which I know is a lot easier said than done. But that's a lesson I hope we learned from this J&J case that I think everybody agrees dragged out way too long.
So we're fast forwarding for a moment, right? It's a team sport. Law is a team sport, and we're all kind of learning from this. We're reviewing all the video. We're reviewing everything that happened. What is the biggest takeaway that we can learn in the last, I'll say, three massive settlement litigations. Like, what's the biggest takeaway that the problem we keep kind of repeating, and that we have to learn from and grow from as a plaintiff bar? Like, what would you say would be the one lesson you would teach a brand new mass tort lawyer? Like, hey, look, don't make this same mistake. We've done it before. This is what you should do.
I think the number one lesson is criteria is king, right? We talked about it last time. It's not the criteria of the marketers. It's not this wishy-washy criteria. It's not maybe this case comes in. This is the criteria. Everybody sticks to the criteria. You have to use this criteria to have a viable claim, because when we don't, it makes it very, very challenging. That would be the number one thing I think we have to all, get on board with. What I have another one that I think is really important that we've seen recently in mass tort settlements. But Andrew, what do you
After
think?
you. No, I want to hear this one.
This is the one I think is the most important, and I've only seen it in the last couple years, but it's the backups for the Bellwether cases. So I think this first came out in Philadelphia Court of Common Pleas, where we have our own mass tort docket. But what we've seen time and time again is we get a Bellwether case and it gets worked up and it's ready to go to trial, and boom, the defendants settled that one Bellwether case. And now what we've seen instead, a couple courts are doing is they've been placing backups for that Bellwether. So there could be one Bellwether case that's the main one that gets worked up, but then behind it, we have 2 or 3 other cases that are worked up simultaneously. So if that first trial date doesn't hold for that first case that settles, we have those other cases that can step in. And so I think holding these Bellwether trial dates are huge, because without it, there's really no pressure on the defendants, right? When we can get away from these Bellwether trials, it just delays and delays and delays. So I've seen some MDL courts, other courts across the country, kind of following that Philadelphia model where we have the backups for the Bellwether. So I think the criteria, the Bellwether backup, would be 2 things that I've seen. And then I'll just say my third one. I loved what happened in Depo Provera with these kind of test cases right away off the jump, right? We had that case settled in about 18 months, 5,000 plus cases. So that model of using these initial kind of bellwether or test cases to identify the issues, without getting dragged down by, right, preemption, Daubert, fact discovery, plaintiffs withdrawing, all of that. I think that's the model we need to see going forward. Obviously, the defendants don't want that at all. But if we could do that, if we could have the criteria agreed upon by the plaintiff's bar, if we could have the backups for any Bellwether case work simultaneously so they can fill in if there's a settlement of that one case, and then if we follow that pilot program from Depo Provera, where we have an initial workup identified immediately while we're also dealing with this general discovery and general issues, I think we could see these cases getting resolved across the board in 3 years.
Joe's right. So you gave credit to Depo. We have to point out that the lawyers on both sides and the judge know each other. Judge Rogers and Brian Alstock led the 3M earplug litigation. You're putting the rocket docket right back with the judge and the lawyer who did it the first time. They know each other. They know how each other works. The efficiency continues to build because of familiarity. Let's just call it what it is. Brian isn't going to file something in Rogers' court that he knows Rogers isn't going to approve. They've spent enough time with each other over the last, 6 years, that he's not going to make basic, stupid first year of law school mistakes. He knows what's expected. And Depo is settling as a rocket docket because there's clear evidence of wrongdoing, and it's a very specific injury attributable to one cause. They were able to chop out every other thing that could potentially cause brain meningioma. And the FDA also sided with, okay, maybe there was an increased risk, but the familiarity of the parties definitely helped there. Takeaway number 2 from all of this is don't get into a fee fight with Chris Seeger. If Chris Seeger has attorney's fees or common benefit awards in this, he's going to win, he's going to get it resolved, and he's going to make a ton of money doing it, but it actually wraps up the program. He's entitled to it. It got done. There was a resolution. He's the original person you do not fight in a fee fight. He won Vioxx. He hasn't lost since. I mean, Chris getting in and appointed at the end, he's Robert, you know what? He's Robert Ory. He doesn't score 30 points a game. He doesn't need to. Everyone else deals with all of the regular, and the game's on the line. He's just not going to miss. Like, that's what he does. He gets put in at when it matters, and it wraps the game up. Last but not least on these takeaways, they're settling in some really weird ways. Like, the structure of some of these relies on all of the basics, regular level of injury, this much money exactly, right? The old school version, like we did in hernia mesh. This injury is worth this much money. That's it. There's no weird point system. There's nothing crazy. If A equals B. But then you get some of these weird ones where, is it going to be a class action settlement? How do we have to deal with the opt-outs? Is it an opt-in or an opt-out? And Joe is right, the defendants almost never hit their blow-off button. We didn't hit enough participation. We're out. Jay Edelson wrote an entire song about the claims rate issue that we're talking about today, where he sings a song called We Don't Talk About Claims Rate, instead of We Don't Talk About Bruno, and how certain settlements got approved with a 1% participation rate. Facebook, I remember that one. But these 95%, can you imagine today, right? These clients haven't been contacted in a year, 2, 3, 4, 5, 10, because it's been going. The MDL got consolidated in 2016, right? So
Yeah.
10 years later, so they've gotten status updates every month and every 3 months. Now they're going to find out that this client's represented by 5 people. And when all is said and done, there aren't 78,000 cases. There's like 50. And then the claims administrator is going to get the dual representations. And then we're going to find out, like every other MDL, that one doctor did something bad. It's going to be the Serena Hoover NFL issue, or how specific asbestos trusts don't take work from a list of disqualified providers, because why would you have a completely clean settlement? Somebody has to try to break the rules because of how much money these claimants might get. Like, that's the next part of settlement administration. He got the settlement done with the grid. Now everyone dumps their stuff in, and whoever is the claims administrator is going to start to notice the patterns of filings, that these certain doctors did this, and then you'll get a fraud, waste, and abuse program in 12 months when the same social security number has popped up 4 other times. And then they'll work backwards and go, okay, this firm's disqualified. Because I don't think there's been an MDL settlement that didn't result with at least one firm getting kicked out, right? Joe, tell me, maybe I'm wrong. I can't remember one where someone didn't get sanctioned or kicked out entirely for filing bad claims.
Yeah, unfortunately, we see that, and that's probably a good topic for another episode.
Yeah.
Would be the claims administration process.
Agreed. And how they have to deal with it, and the way that we talked about it last time. Product in place cases are not cases. They're not going to get paid. And the nuclear verdict sets unrealistic expectations that you have to then explain to the client. And I wish they all got days in court. We just would need 10,000 more courts and 10,000 more qualified judges and lawyers to do every one of the cases. It's just mass torts were created for a reason, right? It's not class action fairness. It's how do you efficiently manage this many injuries nationwide? It's not perfect. I'm sure there's a better way to do it, or we can make little incremental approvals, but I guess it's better than not having one at all, right? Maybe.
Absolutely. Absolutely. And this is why I love you guys and I love having you on. And this is, I just enjoy. I learned so much. I'm gonna start calling this our jam sessions, our Joe, Andrew, Michael
Love
jam
that.
session, legal jam sessions, and I welcome you guys regularly because this is so important to share these different insights and share back and forth about different learnings and where we've went wrong and how we can improve, and then in general just what to look out for people who have been in this industry for a long time, and then for people who are just kind of jumping in for the first time, because there's plenty of personal injury lawyers and criminal defense lawyers and just lawyers in general who are jumping in going, hey, I would love to represent some people in XYZ tort and litigation, and I want to get smarter about this. And, what does Joe have to say? What does Andrew have to say? What are some things I can learn so I don't make the same mistakes? And so this is lovely. I love these conversations, and we're gonna have a discussion coming up as well on Roundup and talk about maybe some Durnell conversations as well at some point. But is there any final thoughts to borrow a Jerry Springer euphemism type deal? Any final thoughts from Joe and then Andrew?
Yeah, I think we learned a lot, over this decade plus in J and J. I think there's a ton of lessons to learn. I think Andrew's spot on with the bellwethers. Like that was a signal that we were maybe in a little bit of a vulnerable position when all of those were coming out. So when we're hearing from the jury, and then I think maybe me and Andrew respectfully disagree about the bankruptcy play and if that's good or bad. But it's definitely something where we're going to see a lot more of, right? Eventually there's going to be a creative attorney on the other side that's going to come up with a way, I would envision, for them to get it to stick in bankruptcy court. And we need to continue to maybe monitor their arguments and see how we can do it. But I think ultimately what we needed was a resolution in this litigation, and we got there. And it's actually a pretty good number considering the circumstances, like Andrew explained. Um, some of these plaintiffs are going to see pretty significant money, and where we were at and the hand we had at that time, it's a good outcome.
I
Andrew?
guess how many attorneys actually made any money on talc given the 10-year run rate and the cost of capital? Do you think, can you imagine? So 10 years, not including, and we're not going to throw out the numbers. I don't think any of the lawyers made money except Seeger. Chris made money because Chris always does. He's never seen a fee fight he doesn't win. You don't want to be on the other side. There's a law review article written about the fact that he is the best attorney to win a common benefit fee fight. He gets in, he does it for his money, he gets it closed, he leaves. But in this one, I think most of the lawyers who got in early lost money doing this. And that in and of itself is the defense strategy going forward. It's on us to get it done faster, but the defendants know what the cost of capital is for plaintiff litigators. They ask for litigation funding docs. And the second they find out that an inventory is accruing interest at 30+% a year when compounded, why would they settle? And that's how you end up in a J&J 10-year fight. Defense counsel goes, we'll just let you keep going. And at the very end of this, I guarantee somebody is going to make $100 million in attorney's fees or more and end up in the red doing it. Watch. I'm not going to say who. I'm going to say at least one, probably 2, 3, or 4. But I guess once and for all, Talc is finally done, assuming that it gets approved. I think it's going to. Joe, do you think it's going to?
Without a doubt, it's done as we know it. You know, the loan pine order's coming. We're predicting the future here. The settlement gets blessed. The loan pine order gets entered shortly thereafter. Talc litigation's done, and some people are upside down, but ultimately the clients, they'll get some money that hopefully can help them, and we move on to the next one.
Final guess, of the 78,000 total claims, how many actually get settled? I'm going to say the number's 42,000.
Yeah, I'm a little higher. I'm in the 50s, 56 to 57.
Should I go $1 just to go on
$1.
I do think it's closer to 60, but that's my wishful thinking. I'm hoping that these women can come out of this on top. But yeah, there might be a lot of dual rep in there, and so the $1 might be the winner. Hopefully not, but we'll see. We've also glazed the heck out of Chris Seeger in this episode, so hopefully hopefully he had a lot of fun watching this too, and he doesn't put us all in a chokehold with his black belt and BJJ as well.
He's a world champion.
I know. That's why he gets these things resolved.
I was just going to say, he's never met a fee fight he doesn't like. He is the definition of why he's a surgeon. You want self-interest. He does his job. He makes his money. He is not leaving a penny on the table. Take it.
That's right. Well, welcome. Love you guys. Thank you for being here. I'm looking forward to our next jam session. I like the jam session. I might just run with that. That's actually pretty fun. So Joe, Andrew, have fun. Enjoy the rest of your week, and we'll meet again next week.
Sounds good, dude.
Thanks, guys.
All right, guys. Thank you, everybody, for watching, and we'll talk soon.